Hello everybody, my name is Pooja Satyogi and today I'll be presenting a paper which I've titled Navigating the Semantics of Anti-Dowry Law and Women's Property in the Special Police Units, Delhi. In this paper, I will be speaking about Delhi Police's Special Protection Unit for Women and Children and the Dowry Prohibition Act of the Indian Penal Code. I began work on this project in 2011 and continued till mid-2014. The genesis of the unit is tied to the enactment of the anti-dowry legislation in India, which was passed in the year 1961. This law was amended in the 1980s following countrywide campaigns over dowry-related deaths, also called bride burning, particularly in northern India. Staffed almost entirely with non-uniformed women police officers, the unit primarily investigates cases of dowry and domestic cruelty, even as a restructuring following a Delhi High Court judgment in 2008 now allows for other complaints of violence against women to be registered and investigated. Domestic cruelty itself, defined as both mental and physical, need not be related to dowry violence. The focus of this paper is only on the Dowry Prohibition Act, which I will now call DPA, and not the specific law on domestic cruelty. But it was important to point out that domestic cruelty forms an important subset of dowry-related laws. I will be making two main arguments in this paper. One, that the criminal law's definition of dowry is borrowed from Hindu religious sources. It is a penal provision ostensibly available to all Indian women, but its borders are sealed by community identities even as it tries to de-link itself from any notion of community. In other words, criminalization of dowry has not divested various forms of exchange during marriage to be rendered in customary terms. While dowry comes under criminal law, disputes of property are civil offences. The anti-dowry law strives to combine these elements, and the result of which is often a legal failure for non-Hindu women. This happens in spite of the fact that dowry has permeated nearly every religious community in India. My second argument deals with the nature of police work at the unit, which is premised on arbitration and reconciliation on the one hand, and to the interpretation of women's property rights on the other. It is here that I contend that the custom-crime binary, which is the central indeterminacy at the heart of the criminal law, reflects on the police's work, in that the police often have to respond to domestic discord arising out of property relations or civil matters without losing sight of the place of domestic violence or criminal matters in kinship. The genesis of a special police unit to investigate cases of domestic violence came to be framed by the anti-dowry legislation. This was because of the common understanding that the reason for violence against women stemmed from the demands made by the Afinal family for more dowry. These demands had escalated in recent decades, presumably because of the collapse of values under modernity. Thus, a major aspect of the work of the unit became oriented towards investigating dowry demands and seeing that a woman was not deprived of her dowry on separation from the joint Afinal family or upon dissolution of marriage. It is here that we see a blurring of boundaries between what constitutes dowry and what forms customary forms of property, both of which in the criminal law borrow from Hindu customary and religious laws. Property that is owned by a Hindu woman is called stridhan, or woman's property. But I'm going to continue using the word stridhan. An important part of the unit's work from the time of their inception has been to make recovery of stridhan possible for an aggrieved complainant, particularly if all attempts at reconciliation fail and the complainant alleges that her stridhan has been misappropriated by her husband or his family members. But how are dowry and stridhan to be defined? According to the Dowry Prohibition Act 1961, dowry means any property or valuable security given or agreed to be given either directly or indirectly by one party to a marriage to the other party of the marriage, or by the parent of either party to a marriage, or by any other person to either party to the marriage or to any other person at or before or any time after the marriage in connection with the marriage of said parties, but does not include dower or meher in the case of persons to whom the Muslim personal law or Sharia applies. Act 3 of the Dowry Prohibition Act penalizes giving or taking of dowry. It reads, if any person, after the commencement of this act, gives or takes or abets the giving or taking of dowry, he shall be punishable with imprisonment for a term which shall not be less than 5 years, and with a fine which shall not be less than 15,000 rupees or the amount of the value of such dowry, whichever is more. The law stipulates that all presents given at the time of marriage to the bride and to the groom to be entered in a separate list and signed by the recipient of the gifts. The value of the present, the law specifies, should concur with the financial status of the gift giver or on whose behalf the gifts are presented to either bride or the groom. If this procedure is duly followed, then the penalty arising from the Dowry Prohibition Act does not follow. Meanwhile, the concept of woman's owned property, or Stridhan, finds mentioned in the Hindu law and constitutes all payments made to a woman in a lump sum or periodically for her maintenance, including all arrears of such maintenance. All movable or immovable properties transferred to her by way of an absolute gift in lieu of maintenance constitute her Stridhan. The Hindu Succession Amendment Act of 2005 enlarged the rights of a daughter, both married and unmarried, and brings her at par with a male member of a joint Hindu family, governed by what is called the Mitakshara law. Mitakshara law itself is a form of legal commentary on the Yajnavalkya Smriti from the late 11th or early 12th century. Its importance for jurists lies in the concept of inheritance by birth, which it explicates in much detail. Over time, Indian courts have attempted to define what constitutes Sridhan within marriage, and of these, Pratibha Rani versus Suraj Kumar of the year 1985 still remains a landmark case in which the Supreme Court defined a woman's property during coverture as consisting of gifts received by the woman on which her husband or his kin did not have any rights, though the husband could use this property in times of distress with a promise to restore it to the woman who is its rightful owner. In Pratibha Rani versus Suraj Kumar, the Supreme Court had held that refusal by the husband to return gift items given to the wife at the time of marriage makes the husband liable for prosecution, and an aggrieved wife can take recourse to filing a criminal case or criminal complaint if the husband or his family members misappropriate property belonging to her. A criminal case, the court held, could be filed in conjunction with civil remedies available to Hindu women under Section 27 of the Hindu Succession Act. In a further clarification, in Ashok Lakshman Kale versus Ujjwala Ashok Kale in the year 2006, the Bombay High Court held that expenses related to marriage and money given as dowry to the groom are not part of Sridhan and cannot be claimed as such. A reading of the definitions of dowry and Sridhan suggests considerable overlap between the two. A strict distinction between them is often not maintainable. Dowry may be part of Sridhan if it is given only to the bride, and some Sridhan may be part of dowry if it was given to the bride in the context of her wedding. Further, gifts presented to the groom and his family in connection of marriage is dowry, but not punishable if a meticulous list signed by the groom is maintained for keeping accounts of things presented to him or his family members. These gifts, monetary or otherwise, although given in connection with marriage, are not Sridhan because they are presented to people other than the bride, and therefore the bride may not claim them as such at a later point. It is common practice in North Indian marriages to display all things presented to the bride by her natal family as part of her Sridhan. These articles usually include, but are not limited to, clothing and linen, jewelry, furniture, household appliances, electronics, kitchenware, car, or even a house if the family is well off, to name a few. Similarly, gifts presented to the bride by the groom and his family, like jewelry and clothes, is also ceremonially displayed at different points in the marriage ceremony. Further, gifts for the groom and his family members may be accounted for via display by the natal family or through a gift-giving ceremony. The acceptable practice in North India is to create documentary evidence of these exchanges through photographs and videos, and not by obtaining duly signed lists by both the bride and the groom or any other members of the family. In Northern Indian affinal kinship, there is always a risk of the groom's family looking down suspiciously upon the making of such signed lists, creating an atmosphere of skepticism and distrust between the two parties at the very beginning of an extended familial relationship. A written and signed list of dowry received at the time of marriage, according to the DPA, would actually safeguard the groom and his family members from fabricated charges of taking dowry through coercion. But the idea precisely of a written and signed list militates against any protection that it may seem to offer. We know from anthropological work on things and actor network theory that documents are capable of carrying, containing, or inciting affective energies when transacted or put to use in specific webs of social relation. I was quoting here from Navarro Rashid. Leaving a paper trail of gifts received in connection with marriage weighs against law's own objective of protection from false cases. My argument here is that demand for dowry seldom ends with the end of wedding ceremony. Rather, the demand for dowry is in most cases a continuing demand, spanning over several years sometimes. More often than not, the only way to keep a record of presents and gifts given to a woman in marriage is through photographic evidence of gift giving or on varying. I'll repeat that sentence. More often than not, the only way to keep a record of presents and gifts given to a woman in marriage is through photographic evidence of gift giving on varying festive occasions, such as ceremonial festivals or special occasions like births of children, particularly male children. It is, however, impossible to keep photographic records of all gifts given to a married woman through her life, for keeping records in this manner is replete with possibilities of fracturing affinal kinship. An important part of the unit's work involved retrieval of Swethan, but in most cases no prior signed list exists. So police officials worked by requesting the complainant to create an itemized list of her property and attach proofs such as photographs and sale receipts in support of the listed items. This practice, rather than established by a statute, has evolved in the units over the years. The list of Swethan is handed over to the accused, who then must account for the items listed and return all the items that are held in his custody, failing which, criminal action under sections 405 and 406 of the Indian Penal Code for misappropriating property may be initiated against him. The negotiations between the two parties are messy, confrontational, and saturated with vitriolic speech, with the presence of a police officer often being the only reason keeping physical aggression at bay, though not always successfully. In my fieldwork, I noticed that for many complainants, it was in their interaction with their inquiry officer or the police officer with whom they were dealing. Both are the same. The police officer is called the inquiry officer. That they first learnt about the limits of what constituted their property, and from among the many dowry items given before or after the wedding ceremony. In the context of depreciating value of their Sridhan, excluding jewelry, many complainants desire monetary compensation, in addition to the return of Sridhan to settle the matter in the unit. In my conversations with many senior police officials who had worked in the cells from their inception, I was categorically told that if a husband did not want to reconcile matters, then they always urged him to hand over the Sridhan articles. It's called Saman Dilwana in Hindi. Failing which, recommendations were made to the local police station to file a formal case. This practice continues till today, except that now a formal case is registered in the police station that is part of the unit itself. Once a complainant receives her Sridhan at the pre-litigation stage, she can file a civil case seeking separation or maintenance of both in a court of law. Further, she can also refuse to accept Sridhan at the pre-litigation level if she feels that her property had been misappropriated or damaged in any way, and continue with the filing of a formal case under sections for misappropriation or misuse of property, or even under section 498A if she feels that she is being harassed by her in-laws for dowry, or even if she wants to make allegations of domestic cruelty which may not be related to dowry. Formal orders for recovery of Sridhan can only be made once a first information report has been filed or an FIR, and a court order obtained to conduct a raid, which can include freezing of bank accounts, raiding them, and raiding, in fact, the matrimonial home itself. All these proceedings can take place only if a complainant has had a Hindu marriage. The DPA also extends itself to the practice of dowry only within the Hindu community, even as dowry exists in some form in non-Hindu communities as well. If a woman complainant from a non-Hindu community alleges dowry-related harassment, then the substantiation of a dowry-related demand can become inconsequential unless the complainant emphasizes domestic cruelty simultaneously, in which case Section 498A, which defines mental cruelty and physical cruelty within marriage, may be invoked. Civil litigation has to be initiated for all matters related to misappropriation of non-Hindu women's property. When women from non-Hindu communities come to the unit, their complaints are admitted within these limitations set by the law, and therefore an attempt is made to reach a settlement in these women's cases through police counseling and mediation. It may be helpful to recapitulate the main points that I have made. I have contended that dowry-related violence burst into publicity in the 1980s, and the creation of women's cell by executive orders has to be understood as a response to the political question of women's protection that defined the decade of the 1980s in India. I have contended that the partibility of criminal law, and here I am borrowing from Marilyn Strathern, I've contended that the partibility of criminal law, with the custom-crime binary being the defining feature of the DPA, has meant that dowry continues to be treated both as a customary practice and a criminal act. Not rendering dowry unequivocally as a criminal act has meant that there is an inherent instability and indeterminacy built into the law's definition, so that the police often have to respond to domestic discord and extended kinship arising out of property relations. A recurring feature of kinship relations, as we know, is that they dissolve and regenerate all the time. Thus, to occupy the place of the police official means to work with a contradictory requirement: facilitate dissolution or reconstitution of relationships, although it is never quite clear where a relationship is moving, and simultaneously prepare for litigation, thereby beginning the process of compiling preliminary evidence. For a police official, getting paperwork in order is as much part of making a complaint file as it is about securing her own position in a context where allegations of siding with the accused party are frequently made. Police work is performed at the interstices of the contradictory logic of criminalizing dowry and making exceptions to it. Therefore, it is important to understand the particularity of laws which have an important bearing on how police work is performed. All too often, in understanding police work, the focus is on the street-level police official's physical act. But I have tried to show here that the capabilities of police work might begin to look very different if we focus on how they are expected to use interpretive labor in a field full of laws' internal contradictions. I will end my paper here. Thank you very much for listening to me. I'd be happy to take any questions arising from this paper.